A company's directors are the people responsible for making decisions for the company, including the decision to trade and incur debt. The title of director can mean any person appointed and registered as such, and any person who is acting in the role of a director with decision-making powers. One of those responsibilities is to avoid trading whilst insolvent. A company is insolvent if it's unable to pay its debts as and when they are due. Section 588G of the Corporations Act makes it legal for a director to continue to incur debt of a company if the company is insolvent. It also makes it an offense for a director to allow a company to incur a debt if the company is insolvent at the time, and the incurring of debt involves dishonesty. A director's responsibility includes keeping themselves informed of the affairs of a company and showing care and diligence in exercising their powers, including the power to incur debt. An important provision in the Act provides a presumption of insolvency of a company where the directors have failed to meet their obligation to maintain adequate books and records. The Act gives liquidators powers to investigate transactions made by an insolvent entity, usually in the months or years leading up to the commencement of a voluntary administration or liquidation, and recover insolvent transactions or seek compensation from the director or directors responsible for the insolvent trading. A liquidator may seek to recover funds for the benefit of creditors from a party involved in a transaction made whilst the company is insolvent. Usually, this is either the director involved in the incurring of a debt or disposition of an asset, or the counterparty who received funds or otherwise benefited from the transaction. Other parties, such as creditors who have suffered damages due to a director's tradings of an entity that is insolvent, may also sue a director or other party for the loss they have suffered. Directors facing insolvent trading actions from a liquidator or creditors have prescribed defenses available to them which are listed in Section 588H of the Act, providing protection against liability for insolvent trading claims. A director may access protection from the consequences of insolvent trading if they are able to prove that at the time the company's debt was incurred, there were reasonable grounds to expect that the company was solvent and would remain solvent. A director has a defense against insolvent trading claims if they can show that at the time of incurring a debt, a competent and reliable person, whom is responsible for providing the director with adequate financial information, believed the company to be solvent. A defense will apply to protect a director from personal liability in an insolvent trading claim when the director was absent from management because of some illness or some other good reason at the time the company incurred the debt. There is also a defense that provides for a director being able to prove they took all reasonable steps necessary to prevent the company from incurring the debt and to be protected from liability for that debt. Directors should be mindful of these provisions when considering their responsibilities regarding any company they believe may be insolvent or likely to become insolvent. In recent years, important changes to the Corporations Act have created a defense against actions for insolvent trading claims, providing they take a course of action likely to lead to a better outcome than an immediate insolvency process. This safe harbor available to directors also carries a requirement to maintain compliance with all employee entitlement payments and to meet all tax reporting requirements in a timely manner. It also requires a director to inform themselves of the affairs of the company, take appropriate steps to prevent misconduct, keep appropriate records, and develop a plan to restructure the company to improve its financial position. An important requirement is for the directors to obtain advice from a suitably qualified entity or person known as the Safe Harbor Advisor. Protection under these safe harbor provisions require proactive decisions by directors, and they need to take appropriate steps at the earliest signs of potential insolvency to achieve protection under the legislation.